Bishop next?
No, ask someone on our side. Yield to me for a second.
Mr. Chairman, I seek recognition.
For what purpose does the gentleman seek recognition?
Move to strike the last word.
Gentleman is recognized.
I'll yield to the gentleman, to the chair.
I thank the gentleman. I just want to point out a few things that have gone wrong with this debate. We're told that the president declassified this material. Aside from the fact that that's apparently not true, even if it were true, it would be irrelevant, because there were several statutes that were violated, which have nothing to do with whether the information was classified or not. Principal among these is the Espionage Act of 1917. If material vital to security of the United States, which this material admittedly was, is withheld or put into a position where it is not properly protected, it is a violation of the Espionage Act, which is a very serious act, whether or not the president declassified that. I thank the gentleman for yielding. I yield back. Who seeks recognition? For what purpose does the gentleman from North Carolina seek recognition?
To speak to the resolution.
Gentleman is recognized.
I thank the chairman. I'm not sure. I wish I had the Espionage Act in front of me, because I'm not sure that's an accurate recitation of it. The Espionage Act would prohibit disclosing information to an enemy, but there's no hint of an allegation that occurred here. The question is that the information was at Mar-a-Lago. You know, I will say that more generally, and Mr. Cicilline still on the dais, I wish Ms. Dean and Ms. Jayapal were, because I think maybe, look, I'll start off by saying that Mr. McClintock often does a great job, I think, of centering the discussion in a way that is reasonable and avoids the excesses perhaps on either side. And I'd sort of like to pursue some of that, because, you know, Mr. Cicilline said, gentleman from Rhode Island, that the president, he was going through a series of claims that he said President Trump has offered, one of which was that he declassified the information. And he said that's ridiculous. And I wonder whether Mr. Cicilline would engage in a colloquy on that point, because I've done a little research on it. I don't purport to be a national security law specialist, but I have looked into it. And first of all, first principle is that the executive, the President of the United States, all power reposed in the President and the unified executive theory of government, has the power over classified information. It's not governed, except for nuclear secrets, which is governed by statute. Everything is governed by an executive order. President Obama replaced President Bush's executive order in 2009. But every president retains the power to dispose of, in the manner he sees fit during his term of office, classified information, to determine whether it should continue to remain confidential. So, for example, Politico has reported, now Politico not a terribly reliable source, but it has reported that, that the reason Scooter Libby wasn't prosecuted for disclosing Valerie Plame's identity, confidential information, is because he was directed to do so either by the vice president or the president at the time. And that would have made it unclassified information, even if there was no formal process. So I wonder how it is. Let's say that in President Trump's records, of course, another thing, members on the committee today have asserted that the president's done this with highly, I think was Ms. Dean's term, classified information, very valuable information. Well, how do you know it is? I mean, the fact that it's just marked or it's got markings of secret doesn't say that it's highly damaging or dangerous information. I mean, anything else you know about it.
The gentleman yield to that point?
I will, just if you'll give me one more second to finish that point. How do you know? I mean, if you know anything, it's based on leaks by the FBI to the Washington Post. And so I don't really, frankly, take that at face value. I will yield to the chairman to comment.
Thank you. Just to answer your question, how do you know? You saw on television the images of those folders, and some of them said classified or something like that, TCI, which is the highest classification. That's how you know it was so classified.
Okay. But that's
Mr.
still
Biggs,
not-
you asked if I would engage in a colloquy. The answer is yes, if you were serious. Mr. Bishop, I'm sorry.
Yeah, I'll yield for a bit. I want to try to get another comment in, but go ahead.
Yeah, no, I just wanted to answer your question with respect to the declassification. I don't dispute that you are correct, that a president has the power to declassify documents. But what we now know is that process, there is an established process to declassify documents. That was not followed, and in fact, Trump's own lawyers don't make that claim in court that they were declassified.
For the purpose of advancing the colloquy, not for diminishing it, let me ask you this question. What regulation do you refer to? I've seen in a number of media reports, they say, but the president would have to go through a process. I've looked to see where that is. I cannot find any law that compels the president to follow a process in deciding to declassify. Merely deciding to put the records, copies of records among his personal, it appears to me, would do it. So what is the regulation, Mr. Cicilline?
I didn't say there's a law. I said there is a process that has been established that every single other president has followed in order to declassify documents. You don't just get to take them home and retroactively say, when you get caught, oh, I declassified them, you caught me.
I think
That's
this
not
is
a process.
possibly illuminating, because you've asserted that there's a process. So what you mean is that other presidents have followed a process, but I gave you the example of the Scooter Libby situation in which they didn't. And there's no reason, if this president decided not to, it's his constitutional authority not to, from what I understand. And I think it's useful to hear these things back and forth, because what comes out in this committee is, you said he did something that appears to be illegal. It's not illegal. It might be not what Barack Obama did, but it's not illegal.
But Mr. Bishop, the National Security Council has to be made aware when a president declassifies documents. It can result in the death of Americans who are keeping us safe. That's why there's a process in place to do it. So the National Security Team is aware of the action of the executive branch. That did not happen in this case. You can't declassify something in secret retroactively only when you get caught with top secret documents stolen from the White House.
I understand why someone could quibble over a judgment call, but that's
not quibbling
not why
over
you
judgment
send
call.
in the
Oh, no,
FBI.
this is not a quibbling over judgment call. This is a direct violation of practice and procedure that is designed to protect the national security secrets of the United States.
It's either a crime or it's not.
The gentleman's time has expired. The gentleman's time has expired. Who else seeks recognition? For what purpose does the gentleman from Oregon seek recognition?
I'll strike the last word.
Gentleman is recognized.
Years ago, I represented a target of a subpoena, and upon receipt of it, I realized that the content that was requested would be, if disclosed, violative of any number of principles of confidentiality. I asked then, obviously, I challenged the subpoena in court, and there were then opportunities to talk about what should be protected and what shouldn't. When I look at the sequence of events that have transpired here, and I look at, by the way, I'll get to the point here in a minute, which of course is our resolution, but when I look at the sequence of events where the Attorney General's office was working with the former president and his team in obtaining various records over the course of over a year and a half, I wonder why the process that was used was not the one that we followed back in our little Oregon, because it's so obvious that the process that was used was not necessary. The process of raiding the former president's home. What should, and it's been raised over and over again that this is not what happened to Hillary Clinton, and this is not what happened in previous similar situations. And instead, the dialogue continued. Certainly not what happened here. The appropriate action here would have been for the grand jury to issue a subpoena for the boxes of material that they had just seen a few days earlier, and then Trump's lawyers would have had the opportunity to challenge the subpoena on various grounds. And then they could have sorted through which material was classified, which material reflected attorney-client privilege. That's what should have happened, but for some reason it didn't. Now, people can go back and say, well, a subpoena had been filed earlier, but that was months earlier. There had been ongoing dialogue right up to the point of the raid. I don't get it.
Mr. Benson, if you'll yield.
No, let me finish. No, I'm not going to yield.
All right.
What I find interesting is because there were alternative tools available for the AG to use, and he chose not to. You have to ask, why would the Attorney General wanted to throw, as I've said earlier in other interviews on this topic, gasoline on a political fire. Why? What could possibly be the benefit? Well, I know, because this is a political matter, and the other focus on issues involving our former president was wearing thin, and this gave an opportunity for a new focus, which is exactly what we're about today. But what we're trying to do is perhaps bring this dialogue to an end by looking at the very affidavit that prompted the raid. Now, that affidavit better contain all kinds of things that say those records were about to be destroyed. Now, you know what? They weren't. The president was 1,000 miles away. So, that's why you go into one of these things with a search warrant, because you fear that there's going to be something that you're trying to lay your hands on that's going to disappear. But I actually, looking at a editorial here, it's important to note that Trump himself was 1,000 miles away when the FBI's search and seizure occurred. It would have been impossible, therefore, for him to destroy the subpoenaed evidence, especially if the subpoena demanded immediate production. If he or anyone else destroyed the evidence to subject to a subpoena, there would have been a far more serious crime than what the search warrant seems to have alleged. What we're asking today is, let's see the affidavit. I mean, what's everybody scared of? We'd like to see it. Maybe it's good, maybe it's bad, but we'd sure like to see it. You know what, that I'm going to yield to Mr. Bishop from North Carolina.
I thank the gentleman for yielding. And I think that, again, and I compliment Mr. Bentz for sort of centering the analysis. If indeed the Attorney General caused an unprecedented in the history of the Republic execution of a criminal search warrant against a former president's residence, when there were other legal options available to solve the problem, it does, I mean, that's what implicates the oversight responsibility of this committee. And it is interesting that it breaks down to, and look,
Mr. Bishop, will you yield for a question?
In 1 second. I want to say this. We issued one Twitter statement that went farther than I wish we had said. We said, I think it was something to the effect of, we must smash the FBI into 1 million pieces. That was the wrong thing to say.
Have you spoken?
We should have said we should break the FBI into 94 pieces. Because they ought to be decentralized. Main justice appears to be the problem. The Washington field office appears to be the problem. We ought to put the FBI under the supervision of United States attorneys and judicial districts all over the country. And there are 94 of those. I wish we had said it that way. Because I do think there's excess rhetoric. But I think when you go back and forth and you stop talking past each other, there are very serious issues to be examined in the conduct of the FBI and the DOJ. And this committee is responsible for that. And if you think back to Senator Harry Byrd, for whatever else you might say about him, and there's much to be said, but he at least respected the prerogatives and the responsibilities of Congress vis-a-vis wrong. So with that, Mr. Bentz, I'll yield back. I don't know if I left enough time for the gentleman from Rhode Island.
The gentleman yields back. Who else seeks recognition?
Well, it's Mr. Bentz's time.
For what purpose does the gentlelady from Georgia seek recognition?
Thank you, Chairman. I move to strike the last word.
Gentlelady is recognized.
I think the very thing that you're espousing is what we're actually trying to do, is make sure that there's accountability, and that is our responsibility on this committee. And at this time, I'd like to yield the balance of my time to my esteemed colleague from Rhode Island to help justify exactly that point.
I thank the gentlelady for yielding. To answer your question, Mr. Bishop, this wasn't the situation that caused the Department of Justice and the FBI to go to a federal judge and seek a lawful order authorizing the search was because of all the other efforts had been unsuccessful. After almost more than a year of pleading and negotiating with the former president and his legal team that they returned documents that the former president stole that don't belong to him, they misrepresented that he had turned everything over. They had not. They misrepresented that they were not in possession of classified documents. That was not true. They sent a subpoena, which is a lawful order compelling you to do something. They did not comply with that law by producing the documents. Their only remaining mechanism to, in fact, collect these documents that, if revealed to our adversaries, could result in the death or a serious danger not only to individuals but to the national security of the United States was to execute a warrant and retrieve them.
Would the gentleman
And- no, let me finish. You had a chance and you didn't want to really engage in a colloquy, so just let me finish. And so the notion that they just did this sort of quickly and didn't exhaust all these other possibilities, look, the execution of a search warrant is a serious effort, no matter who it is. It's a particularly serious effort if the subject of the target of that is a former president of the United States. But so is the conduct of the former president deadly serious. And you don't get to hide behind having been the president to cover up or engage in conduct which is unlawful and to say you shouldn't be held accountable. So you're right, it's serious, but the conduct of the former president was also unprecedented and serious. So first of all, let's not suggest that the FBI and the Department of Justice and the archives didn't try desperately to get back these documents that the former president had no right to take. And by the way, taking of them was a violation of federal law, failing to secure them is a violation of federal law, and failing to return them upon lawful demand for their return is another violation of federal law. So there's no question that they tried as hard as they could to retrieve these documents. The former president and his team misrepresented, lied, and refused to turn them over. So that's number one. Number two, someone made the suggestion, couldn't they just go in and see the documents are there and then go back and ask for them again? Why did they have to execute a warrant? The only reason they knew they were there was because they executed the warrant. They had lied and been told, we've given you everything. We don't have anything else. So the notion that the former president was in New York on the other side of the country didn't mean that those documents were safe or the danger to the American people or our national security was diminished in any way. The idea that we're talking about some of the most secret kinds of information that are essential to the safeguarding of the national security of the United States, that those were unsecured, stuffed away in a golf club where all you have to do is write a check to become a member, and that is not disturbing? And then the claim that, oh no, we're not really attacking the FBI. One of your colleagues was selling T-shirts that said, defund the FBI. Her name is Marjorie Taylor Greene. I don't know if anyone in the Judiciary Committee bought those T-shirts, but look, I spent my career battling with the FBI. I was a criminal defense lawyer. But I always recognized the value of law enforcement and the importance of respecting the institution of the court and of law enforcement. And when a judge reviews an affidavit and signs it saying there is probable cause to believe that there is evidence of crime at this location and that there is some danger that that evidence will not remain secure and safe and poses a danger, and is evidence of crime or a cover-up or a conspiracy, the judge signs that. That judge then authorizes the lawful execution of warrant. There's nothing illegal about it. It happens every day in America for people who commit crimes. And so I just wish all of this fussing about, geez, you have a lot of concern about the FBI. What about a little bit of concern about the conduct of the former president? I haven't yet heard a single Republican on this committee in this hearing condemn the taking away of classified documents and stuffing them in your golf club without legal authority, refusing to return them, and thereby really undermining not only the national security of the United States, but the ability to keep our country safe. So I thank the gentlelady for yielding, and I yield back.
Gentlelady's time has expired.